You're standing outside your home. A car pulls up, two men in tactical vests step out. One of them says four words that make your stomach drop. Are you a citizen? Your heart is hammering, your mind goes blank, and in the next 30 seconds, what you say, or don't say, will determine whether you walk back inside your front door or get put into a vehicle. Every single day across America, people face ICE encounters and make the same three critical mistakes. They panic, they overshare, and they don't understand that the Constitution applies to this moment, right now, whether you're a citizen, a green card holder, or undocumented. They don't know that answering the wrong question or opening the wrong door hands federal agents legal justification to detain and investigate further. But knowing three exact lines changes everything. I've reviewed hundreds of documented ICE encounters, studied every major Supreme Court rule, and if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Ruling on immigrant constitutional rights, and analyzed how these encounters legally unfold from first contact to detention. I've identified the three phrases that protect you at each critical decision point of an ICE encounter. Miss one and you've handed over legal ground you cannot get back. Use all three and you've done everything the law allows to protect yourself. Before we go further, this is educational content only. It is not legal advice. For your specific situation, consult a qualified immigration attorney immediately. Now let's break down the three mistakes and the three lines that stop them cold. Mistake 1. Answering, "Are you a citizen?" The mistake. The agent approaches you on the street or outside your home. He asks the question directly. Are you a citizen? Where were you born? Are you here legally? Most people answer. They think cooperation looks better than silence. They think answering honestly will end things faster. They answer, and in doing so, they hand the agent the foundation for everything that follows. The scenario. You're walking to your car in the morning. Two ICE agents approach. One shows a badge. Can I ask you a few questions? Are you a citizen? You hesitate. You say no, or you say you have a visa, or you try to explain your situation. The agent nods, keeps asking. What kind of visa? When did it expire? Where do you live? Every answer you give builds a file. Every answer narrows the investigation directly onto you. Why people do it? People believe that being transparent makes them look innocent. They think silence looks suspicious. They think the agent will leave them alone if they just answer clearly. But agents are not conducting a conversation. They are conducting an investigation. Every question has a legal purpose. Your answers are not going to make them leave. Your answers are going to help them build a case. Legal reality. The Fifth Amendment of the United States Constitution states that no person shall be compelled to be a witness against themselves. The Supreme Court established in Matthews v. Diaz, 1976, that the Fifth Amendment protects every person within the jurisdiction of the United States, not just citizens. The court stated plainly that the amendment applies to, quote, literally millions of aliens. In Plyler v. Doe, 1982, the Supreme Court reaffirmed that undocumented individuals are persons protected by the Fifth and 14th Amendments. Your immigration status does not strip you of the right to remain silent about your immigration status. That is established constitutional law. The evidence problem. Everything you say in a public encounter can be used in removal proceedings against you. There is no Miranda warning before an ICE encounter on the street. There is no requirement that agents tell you that your words will be used against you. If you confirm you are undocumented, you've done their job for them. Agent psychology. Agents are trained to open with conversational questions, casual tone, non-threatening posture. Just a few questions. Most people answer because the interaction feels informal. It isn't. From the moment they approached you, it was official. The correct move. Here is line 1. Say it calmly, respectfully, without hostility. I am exercising my right to remain silent. That's it. Not an argument. Not an explanation. Not an apology. You are not being rude. You are invoking a constitutional right that the Supreme Court has confirmed applies to you in this moment, regardless of your status. If they ask again, repeat it. I am exercising my... And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. My right to remain silent. Why it works. This does two things simultaneously. It stops the flow of information the agent is gathering, and it creates a record, if the encounter is documented, that you did not waive your rights voluntarily. You cannot be punished legally for asserting a constitutional right. The agent cannot use your silence as evidence of guilt in removal proceedings. You've protected the most important thing. You haven't handed them your case on a plate. Bottom line, never answer questions about your citizenship, birthplace, or immigration status without an attorney present. The only answer is, I am exercising my right to remain silent. Mistake 2. Opening the door. The mistake. The knock comes. It could be 6 a.m., it could be midday. You hear ICE open up, and most people open the door. They open it because the command sounds official. They open it because they're frightened. They open it because they think they have no choice. That one action and opening that door without checking for a judicial warrant is the single most consequential mistake you can make during a home encounter. The scenario, you're inside your apartment. Hard knock. Immigration enforcement? Open the door. Your family is watching you. You don't know what to do. You open the door 6 inches to see what they want. The moment that door opens and agents step forward, the legal dynamics of the encounter shift dramatically. What began as a knock outside your home is now inside it. Why people do it? People assume that law enforcement always has the legal right to enter. They assume a badge and a command equal authorization. They don't know the difference between an administrative warrant and a judicial warrant. And that difference is everything. Legal reality? The Fourth Amendment guarantees the right of all people to be secure in their homes against unreasonable searches and seizures. The Supreme Court has been consistent across decades of rulings that the home is where Fourth Amendment protections are strongest. An ICE administrative warrant, a form called an I-205, which is signed internally by an immigration officer, not a judge, does not authorize forced entry into your home. Courts have ruled repeatedly that administrative warrants lack the independent judicial review the Fourth Amendment requires. A judicial warrant is signed by a federal judge and specifically authorizes entry to a named address. It looks different. It says search warrant or arrest warrant at the top. It has a judge's signature. An I-205 form does not. The Brennan Center for Justice, analyzing current ICE policy, has confirmed that the agency's own historical practice acknowledged that administrative warrants alone did not authorize home entry, a position reversed by internal memo in May 2025, a reversal that is currently being legally challenged in federal courts. You have the right to ask which type of warrant they have without opening the door. Evidence problem. If you open the door voluntarily, courts can interpret that as consent to the encounter. If agents enter and you've opened the door, challenging what happened inside becomes significantly harder. Your voluntary action erased the protection the Fourth Amendment was giving you. Agent psychology. The command to open the door is designed to sound like an order. ICE open up sounds mandatory. Most people respond to the authoritative tone without asking whether they're actually legally required to comply. You don't have to open that door to speak with them. The correct move. Here is line 2. Say it through the closed door, calmly and clearly. Do you have a judicial warrant? Please slide it under the door. Do not open the door. You can speak through it. You can speak through a window. You are not required to open your door to ask this question. If they say yes and slide a document under the door, examine it. If it has a judge's name and signature and specifically authorizes entry to your address, that is a judicial warrant and you must comply. If it is an I-205 administrative form signed by an immigration officer, say clearly, "This is an administrative warrant. I do not consent to entry." If they say they don't have a warrant, do not open the door. Why it works? This question immediately forces the agents to confront the legal basis of their entry. It puts the burden on them to show judicial authorization. It creates a record that you asked. If they enter anyway without a judicial warrant and without your consent, you have documented a potential Fourth Amendment violation. Your attorney has grounds to challenge everything that followed. Bottom line, Never open your door for ICE without first asking for a judicial warrant with a judge's signature. The correct line is, "Do you have a judicial warrant? Please slide it under the door." Mistake. 3. Signing documents without a lawyer. The mistake. You've been detained, or the encounter has escalated and agents are asking you to sign paperwork. Most people sign. They're scared. They want to cooperate. They think signing will help. They think refusing makes things worse. Signing those documents without an attorney may be the most permanent mistake of the entire encounter. The scenario: you're in custody. An agent places a document in front of you. This is just standard paperwork. Sign here. You don't fully read it. You don't fully understand it. You sign. What you just signed may have been a voluntary departure form, waiving your right to an immigration hearing. It may have been a form accelerating your removal. It may have been a statement used as evidence against you. You can't unsign it. Why people do it? People in detention are frightened and exhausted. They believe that signing will speed up their release or make agents treat them better. They can't read English well enough to understand what they're signing. And no one tells them that signing certain documents can permanently eliminate legal options they didn't know they had. Legal reality. The Fifth Amendment's Due Process Clause applies to all persons in the United States, citizens and non-citizens alike, in formal removal proceedings. The Supreme Court confirmed this in Matthews v. Diaz and in Zadvitas v. Davis, 2001, where the court stated the Due Process Clause applies to all persons within the United States, including aliens, whether their presence is lawful, unlawful, temporary, or permanent. You have the right to be represented by an attorney in immigration proceedings at your own expense. You have the right to a hearing before an immigration judge in most circumstances. Signing documents without understanding them can waive those rights permanently. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Permanently. The American Immigration Council has documented extensively that immigrants who have legal representation are significantly more likely to receive a fair outcome in immigration court than those who do not. Evidence problem. A signed document is almost impossible to challenge after the fact. Courts treat a signature as knowing consent. Even if you didn't fully understand what you were signing, proving that after the fact is an extremely high legal bar. The moment you sign, that document works against you. Agent psychology. Agents present paperwork as routine and non-threatening. The framing is always casual. This is just standard. Everyone signs this. This will make things faster. They don't explain what you're waiving. They are not required to. The correct move. Here is line 3. Say it firmly, calmly, and repeat it every single time a document is placed in front of you. I do not sign anything without my attorney present. That's the line. Every time. No exceptions. If you don't have an attorney, you are still entitled to ask for one before signing anything. State clearly, I want to speak with an attorney before I sign anything. Why it works. This statement creates an unambiguous record that you did not waive your legal rights knowingly and voluntarily. It prevents you from signing away your right to a hearing, your right to appeal, or your right to contest the factual basis of the action against you. An attorney can review any document before it's signed and tell you exactly what you're waiving. Without that review, you're flying blind in a legal process that is specifically designed by trained professionals. Bottom line, never sign any document during or after an ICE encounter without your attorney present. The line is, I do not sign anything without my attorney present. The 3 lines one more time. Write these down. Put them in your phone. Make sure everyone in your household knows them. Because in the moment, when your heart is racing and agents are at your door, you will not have time to think. You need these automatic. Line 1. When asked about your citizenship, birthplace, or immigration status, I am exercising my right to remain silent. Line 2. When agents knock at your door, do you have a judicial warrant? Please slide it under the door. Line 3. When asked to sign any document, I do not sign anything without my attorney present. These 3 lines are not confrontational. They are not arguments. They are constitutional rights that the Supreme Court has confirmed apply to every person physically present in the United States in rulings dating back over a century. You are not breaking a law by using them. You are following one. Write down the number of an immigration attorney now before you need it. Organizations like the American Immigration Council and local legal aid societies can help connect you with representation. Some provide emergency services. This is educational content only, not legal advice. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. For your specific situation, consult a qualified immigration attorney in your state immediately. If this gave you something important, share it with your family, your neighbors, anyone who needs to know their rights before they're standing in the moment where it matters. Everyone on American soil deserves to know what the Constitution actually says about them. The Constitution doesn't protect people who know the right things to say by luck. It protects people who know the right things to say by preparation. Stay calm, know your lines, and do not sign anything.